Here in the appeal of Gordon Winter Company Limited against NH International Caribbean Limited.
Yes, Mr. Mitchell.
Good morning, my lords. In this appeal, I appear for the appellant alongside Mr. Rashina Ryan, and we are instructed by Ms. Imogen Webb of Ward Hathaway. And for the respondent is Mr. Ian Benjamin, Senior Counsel, and he's instructed by Ms. Tammy Lee.
Thank you.
May I begin, my lord?
I'm sorry?
May I begin?
Yes, please. Yes.
The appeal before this court arises from the judgment of the Court of Appeal dated the 27th of October 2023, whereby that court, among other things, found that a contract existed between NH International Caribbean Limited, the appellant here, and Gordon Winter Company Limited, the respondent, under which Gordon Winter had agreed to act as NH's subcontractor in respect of certain piling works in relation to a new Ministry of Education.
You can take it, Mr. Mitchell.
Yes.
We've read the papers quite thoroughly because we're conscious that we've only given you half a day. And so we can get straight to the nitty-gritty
I'm obliged
as soon as you like.
I'll get straight to the meat of the matter. The issue on this appeal is essentially whether in the circumstances of this case it was open to the Court of Appeal to find in favor of Gordon Winter in respect of a cause of action which it did not plead or disavowed or submit upon a trial which NH had no opportunity to defend, which we say, and whether which it is inconsistent with the cause of action in fact pleaded and relied upon by Gordon Winter at trial. We submit that this is precisely what the Court of Appeal did when it found that a contract existed between the parties and thereafter allowed Gordon Winter's claims identified at paragraphs 2 and 6 of its order, which forms part of the bundle. In this appeal for the avoidance of doubt, we submit that NH is not challenging the Court of Appeal's order in respect of any of its counterclaims, but the focus is essentially on the claims which have been allowed in favor of Gordon Winter.
Yes.
Our arguments in summary are, first of all, that the judgment of the Court of Appeal is wrong and cannot be sustained for the following reasons. One, allowing Gordon Winter's claims in contract, as it did, was contrary to the rules and the requirements as to pleadings because Gordon Winter had not pleaded a case in contract. Secondly, we submit that it was not open to the Court of Appeal to find for Gordon Winter in contract, given that Gordon Winter had elected to run its case in the High Court in restitutionary quantum meruit. In so electing, it had foreclosed any possibility of running a case in the Court of Appeal or pursuing an appeal on the basis of the existence of any contract, whether that be a contract in respect of which payment is based upon the existence of an implied term or some express term. The third argument we say is that the basis upon which the Court of Appeal found for Gordon Winter was not a basis relied upon by Gordon Winter, either in the High Court or the Court of Appeal. And in those circumstances, the Court of Appeal was compelled to reject rather than to allow Gordon Winter's claims. And the fourth point we make is that allowing the judgment to stand would be manifestly unfair to NH in that the judgment would have been given in respect of a case which NH was, one, never called upon to meet at trial, two, did not have the opportunity to plead to or run a defense to, more particularly in circumstances where it might have had contractual defenses available to it, and three, it hadn't filed a defense to the claim.
Three was what, sorry?
It had not filed a defense to the claim.
It had a defence, did
No.
it?
Well, we say possibly it had a defense.
Yes.
And the third point we make is that it didn't actually file a defense
It didn't file,
to
sorry.
a breach of contract claim. So yes, it filed a defense in the proceedings, but the defense was not to meet the claim upon which the Court of Appeal found in favor of Gordon Winter. And the point we make there, if I can expand upon it a moment, is one of the issues before the board is whether the Court of Appeal found on a contract with an express term to payment or an implied term, contractual quantum merit. We say whichever position the board finds the contract was, matters not, because NH was not called upon to meet either of those cases. I consider it a convenient point perhaps to take the board to what the Court of Appeal actually found. Because I think this is there are paragraphs in the judgment which help illuminate the issues and the actual findings of the Court of Appeal. So insofar as is relevant to this appeal, we say that the Court of Appeal found that a contract came into existence between the parties in respect of piling works. And for the record, that can be found at paragraphs 7, which is page 254 of the electronic bundle.
254.
254. Paragraph 18, Roman 1, at page 257. First line. Paragraphs 50 and 51 at page 273. Paragraph 200 at electronic page 315. Last two lines of that paragraph. And paragraph 261 at page 334 of the electronic bundle. The relevant terms of the contract, this is what the Court of Appeal also found, were to be found in 4 documents. Those documents are identified at paragraph 7, which is at page 254, and again at paragraph 261, 334.
Sorry, what was the second reference? 261?
At page 334 of the electronic.
Thank you.
Now, importantly, the Court of Appeal found that incorporated into those documents, or part of those documents, was the 1999 standard FIDIC terms. And that formed part of the contract and was incorporated by reference. You will see the reference to that at paragraph 7, Roman 1, page 254. At paragraph 8, 255, 37,
Sorry.
37, at page 267, forgive me, and paragraph 189 at 310. Now, the FIDIC terms themselves, the Court of Appeal also found, they did provide for and plainly address 2 things. 1, the measurement.
Now, the standard terms are those, somewhat surprisingly, at the very end of the authorities bundle.
Yes,
Yeah.
yes, they are.
For a case in which they're said to be crucial to the whole.
We had suggested perhaps that they be placed elsewhere, but we were guided that the authorities bundle might have been the better place. They are also in the, I think they're attached to the witness.
They're probably an extra witness statement or something,
Yes.
but if it's convenient to you,
Yes,
the authorities bundle seems to be a convenient place to find them.
very well. Yes. So those terms, we say, did in fact plainly address the measurement and evaluation of works including varied works under Clause 13. And the Court of Appeal's finding in that regard is reflected in at least 3 places. One is paragraph 13 of its judgment at page 256.
Sorry, paragraph
1-3,
13.
yes, at page 256.
Yeah.
Again, at paragraph 37, page 267. And 43 at page 271. And the second thing the FIDIC terms addressed, and the Court of Appeal found that those terms addressed, were matters such as variations, delays, and unexpected physical conditions. And you can pick that up at paragraph 46 of the judgment at page 271. And also if one reads paragraphs 188 and 189 together at page 310.
And one doesn't have to crossing through the Court of Appeal's analysis at this point. I mean, if the standard terms are binding,
Yes.
well, we can read them.
Yes,
Yeah.
yes. Significantly, we say in respect of those FIDIC terms, there was a provision under Clause 13 and 12.3 that provided a mechanism for the valuation of variations. And finally, as to the findings of the Court of Appeal, what the Court of Appeal also found is that those terms covered all the claims made by Gordon Winter, save and except for 2 claims, which it determined had been made in restitutionary quantum merit and had failed on its findings. That would be manufacturing standby and storage of piles and other materials. And you see that reflected in various places in the judgment and also in its order.
So you say it covered all but 2 of those claims, but they both failed.
Yes, and those claims are not material for the purposes of this appeal. Now, a number of points.
Just for our understanding, can you just elaborate what standby means in this context?
Well, I think there was some debate about that in the court below. What we say is that the standby costs are essentially delay costs, because the contractor had to maintain equipment on site, waiting for the implementation of instructions to vary the piles.
Right, thank you.
And if I can say broadly, we say there are essentially 2 categories of claims. There are, in one bucket will be claims which are variations, which were instructed by the engineer, and then in the second bucket we say there are delay claims. And importantly, we also submit, and I will come to the provisions in a little bit, that FIDIC caters for both. There are express provisions as to what is to happen in both of those circumstances. Now, one of the most important things in the context of this appeal, we say, which arises out of the judgment of the Court of Appeal, is that having found that FIDIC provides for a mechanism for evaluation and for payment, in those circumstances, there is no room for contractual quantum merit, which is predicated on the implication of a term that a reasonable fee or price is to be paid.
Unless one was to say, well, the parties clearly weren't bothered about the express mechanism, and in that sense they may both regarded as having waived it.
I accept that, my lord, but I will say, on this case, there's been no finding either in the High Court or the Court of Appeal. So, in our respectful submission, while that is theoretically possible, it's not a premise for either of the judgments in this case. And especially in the face of the Court of Appeal's express finding that these terms do apply. One would have expected, if that was the case, the Court of Appeal would have made an express finding to the contrary, that they don't apply. Although, contractually they may have been there, the parties disapplied them by their conduct or some express agreement. That doesn't arise in my respect. So.
But it would provide a clear explanation. I mean, on the one hand, you're saying, well, the Court of Appeal saying it's contract, these are the terms of the contract, but they end up with a contractual quantum meruit, in effect.
Well,
I mean, isn't a rational way of understanding is that they must have assumed that the express terms were just not bothered with by the parties. Otherwise, it becomes irrational.
With respect, no, we don't accept that they end up with a contractual quantum merit, and the reason for it is this. And there are aspects of the Court of Appeal's judgment that could have been clearer, but what you will see is when one looks at Clause 13, which is the mechanism for payment and valuation. Clause 13 of FIDIC, and perhaps I can take the board to it, it may be convenient. It's at the end of the authorities bundle.
Page.
It is at page 4107.
4147?
4107.
107, thank you.
Yes.
Yeah.
And what the important point I make, if one looks at clause 13.3, this is a variation procedure. But if we go over the page to 4108 at the end of clause 13.3, you will see that there's a provision there that says each variation shall be evaluated in accordance with clause 12, measurement, unless the engineer instructs or approves otherwise in accordance with this clause.
Where is that?
So where that then takes you to next. Have I lost you, my lord?
You have momentarily, yes, I'm sorry.
Yes. 4110? No, forgive me. 4108.
4108?
Yes.
Yes, clause?
The last paragraph of that clause, beginning each variation.
Yes.
So that's part of clause 13.3. But what that tells you is when you come to evaluate it, you must go to clause 12. So when one goes to clause 12, and in particular clause 12.3, which begins on 4105 and goes over the page to 4106, there is a fairly detailed mechanism. If I can summarize the mechanism, it's if works are provided for, if there are existing rates to value works, you can apply those rates or you can extrapolate them in relation to similar work. However, if no new rate or price is appropriate for an item of work, there is a formula which is set out. But importantly, in the penultimate paragraph of 12.3, you see it says this: each new rate or price shall be derived from any relevant rates or prices in the contract, with reasonable adjustments to take into account of the matters described in subparagraph A and B as applicable. If no rates or prices are relevant for the deviation of a new rate or price, it shall be derived from the reasonable cost of executing the work. So, in answer to Lord Burroughs, my submission is that you will see in certain parts of the judgment of the Court of Appeal, Justice Rajkumar does make express reference to Clause 13 and Clause 12.3. And the factual backdrop to the case is that the parties had not, in fact, agreed rates. So my submission would be when you come to read his judgment, you have to read it recognizing that he was alive to Clause 13 and also alive to Clause 12.3.
Yes.
Knowing full well that the parties had not agreed. So the reference to reasonable cost, or...
But if the facts were that the extra work was instructed,
Yes,
it was done,
yes,
and the engineer didn't value it in accordance with clause 12.3, which
Yes.
seems to be the engineer's initial responsibility.
Yes.
And the only other contractual provision is that it should be a reasonable
Cost.
cost.
Yes.
And the engineer hasn't done it,
Yes.
hasn't produced that reasonable cost. Why can't the contractor come to court and say, well, please value it for me?
Well, the first reason, my lord,
Doesn't
is
that
this.
take you to the dispute resolution provisions in the standard terms?
My answer to that is this, my lord. If the contractor, in all circumstances, the contractor is bound by the terms of the contract. If the contractor comes to court with a contractual claim and he says, look, the engineer hasn't done this, work out this value for me, NH is then faced with a claim in contract. When that claim in contract is engaged, NH then says a number of things. Okay, the first thing is, these are works which arise out of unforeseen ground conditions, clause 4.12. Similarly, there's a variation procedure. Similarly, there's a clause 20.1 procedure. All of these clauses, well, most of these clauses, require you to serve notice as a condition precedent to payment. So it is not, in my respectful submission, a simple question of saying quantum merit, contractual quantum merit will give you a reasonable rate, and under the contractual provisions, you will also get a reasonable rate. That analysis misses the fact that if you engage a contractual claim, you must comply with the contractual procedures and then allows the contractor an opportunity to say, hang on, these provisions which we have mutually agreed to under the contract allows me to interrogate certain defenses. And in fact, you have not provided any notices, you have not satisfied the condition precedent, and there's no liability. Now, what you will see in the evidence, I mean, while there's some discussion about the rates, and it might be a reasonable rate, there's no discussion about notices. There's no evidence of that in the record. So I accept immediately that probably you might end up in the same place as the quantum, but the route by which you get there is fundamentally different. And if one approaches it from a pure contractual quantum merit approach, what you are doing to get there is you are disavowing the express provisions of the contract, and you are depriving the main contractor, NH, of an opportunity to avail itself of defenses which it certainly had contractually.
Can I just be absolutely clear? So in 12.3, penultimate paragraph, second sentence,
Yes.
are you suggesting that that is not equivalent to a contractual quantum merit? Or are you saying that that is, for all intents and purposes, the same as a contractual quantum merit?
My lord, I accept that when one comes to the assessment, you may well end up in the same place. I'm not disputing that, right, in terms of value. But there is value is at the end of the road. Yeah. There is a process along the way.
I understand that point.
Yes.
But if the Court of Appeal has ultimately, if you like, gone to 12.3,
yes,
it would be legitimate to call that a contractual quantum merit, would it not? Your objection is, well, they've got there without the conditions that trigger that, effectively the need to serve a notice and the like.
That's part of my argument, my lord, but I say it can't be a contractual quantum merit because the premise of a contractual quantum merit is actually the parties have not made express agreement as to how the price is to be worked out. And if one, I mean, I don't want to belabor the point, but if you look at clause 20 of FIDIC as well, you will see that there are other responsibilities. It's at page 4128 of the electronic bundle. And you will see this. The opening words of clause 20.1 tell you that if the contractor considers himself to be entitled to any extension of time for completion and/or any additional payment under any clause of these conditions or otherwise in connection with the contract, he shall give notice to the engineer describing the event or circumstances of the claim, and it goes on. The second paragraph says, in terms, if the contractor fails to give notice of a claim within such period of 28 days, the time for completion shall not be extended, the contractor shall not be entitled to additional payment, and the employer shall be discharged from liability in connection with the claim. So these provisions are of enormous import in our respectful submission. And one cannot get around them and say, well, quantum-wise, you might have achieved the same. What's the quarrel about now? Well, the quarrel is if one proceeds on a contractual quantum merit analysis, it throws out the provisions on the contract and multiple defenses which a contractor may be able to avail himself of.
So, right. Well, I was just going to ask, do you say that no notice was given? Do you say?
Well, I say this, my lord. On the evidence, there's no any evidence of notice. But I think it is important to be made for this point to be made. The question of notices was not an issue. NH did not have to run a case by way of defense. Look, the contractor did not serve any notice. And the reason it didn't have to run that case is because it wasn't being called upon to answer a claim in contract.
But, I mean, there's reference to a letter which was oddly dated the 31st of April 2006, which was sent by GW.
Yes.
With, we're told, a detailed claim for additional payments. Now, I haven't myself looked at it. It's in the bundle. It's about 5 pages long, I think. But could that not stand as a notice under clause 20.1?
The short answer, my lord, is no one is really in a position to assess that now because there was no examination of it at the time. Remember, clause 20.1 says there is a time frame within 28 days of the event or circumstance giving rise to the claim.
Well, I mean, the letter is dated the 31st of April.
Yes.
So, provided the event occurred within 28 days before then, it would be in time, assuming it met the requirements of 20.1.
It might be, my lord. It might be. But I'm not...
The question is whether there's any... I mean, if there's a serious argument about whether that satisfies the requirements of 20.1, that is one thing.
Yes.
But if it actually clearly does satisfy the requirements, well, this is a point without any real substance.
Well, my lord, with respect, I don't accept that. And the reason I don't accept it is that that is proceeding on the premise that these are the only defenses that might be available to the contract. And in my respectful submission, it would be unfair. It would be manifestly unfair now to tie the contractor to whatever material might be in these papers at this stage, in circumstances where the contractor never had an opportunity and was never called upon to answer a breach of contract claim. It might be simple to confine ourselves to these papers now and say, on this analysis, this is where we end up.
But I mean, in a sense, whose fault is that? The claim is pleaded in quantum merit, and at its barest essentials, taking away the legal jargon, is the claimant saying, I did this work which I was asked to do, and I'm entitled to be paid a reasonable price for it. To which your side says, well, it's all governed by a contract. But if the contract also says that the claimant is entitled to be paid a reasonable price for that work, you've got to go on and say rather more, haven't you? You've got to say, and what's more, the contract imposes all sorts of conditions which weren't complied with.
I don't accept that, my lord. And the reason I don't accept that...
Why not?
Because when one looks at the claimant's pleaded case, what the claimant says in terms is that he is not coming in a contractual claim.
Well,
he says
I appreciate that, but
yes.
in an ordinary, take a terribly simple case. If a claimant comes and says, look, I've done this work at somebody's request, I want a reasonable payment for it, and doesn't mention any contract, it's no good for the defendant simply to say, well, there was a contract, and it makes exactly the same provision, which is, if you do the work, you get a reasonable payment for it. Why is that going to stop a judge ordering a reasonable payment?
Because, my lord, in our submission, it is up to the claimant to choose how it comes to court, what cause of action it is going to activate. Any claimant could plead alternative cases. In this case, the claimant elected not to plead an alternative case. That's the first point. When the claimant is met with the defense, which says contract, the claimant disclaims the contract and says in its reply, doubles down, it says there is no contract. The claimant then continues throughout the course of the proceedings in the High Court to disclaim the contract. I think this is a useful question to ask, my lord. If the defendant is to plead in respect of a case for breach of contract, what is really the defendant responding to? Normally, one would expect an allegation of breach. Conditions in the contract would be set out. If the defendant is to plead it, the defendant can only speculate, and it is not the defendant's job.
Yeah, but I mean, this is a little bit theoretical in a way. I mean, what I would be quite interested in knowing is what contractual defences were available to your client if it had been put on a contractual basis.
All I can say at this stage, my lord, is I have identified the clauses that relate to potential contractual defenses, which are at least at minimum the notices, which are required under clause 4.12 in relation to unforeseen ground conditions. Perhaps if I can take my lord to it.
Do you deal with this in your written case?
Very, very briefly, my lord.
All right, well, by all means, expand on it now.
Yes.
Yes.
If one looks at page 4086, unforeseen physical conditions. 4086. And if I can invite the board to look at the second paragraph of that clause.
This is clause 4.12,
4.12, my lord.
thank you.
You will see in the second paragraph, it speaks of if a contractor encounters adverse physical conditions, which he considers to have been unforeseeable, the contractor shall give notice to the engineer as soon as practical. And that's the domain we are in here. Then if we go down to the last paragraph on the page, beginning, if and to the extent that the contractor encounters physical conditions which are unforeseeable, gives such a notice and suffers delay and or incurs costs due to these conditions, the contractor shall be entitled, subject to clause 20.1, and then subclause B, the payment of any such costs which shall be included in the contract price. So that is yet another provision. But to finally answer my lord on it, we submit that it just can't be right at this stage to be saying, well, what other defenses did the contractor have in circumstances where he did not have to answer a breach of contract case?
So in terms of the provisions of the standard term fitting provisions, in terms of what should have been complied with and arguably was not complied with, you've got 4.12, which you've just taken us to, you've got 20.1, the notice, and you were showing us the adjudication or the
Under clause 13 and 12.3.
13 and
Yes.
12.3.
There's adjudication, and then there's an arbitration clause.
Indeed, my lord. Indeed.
Do you rely on either of those as barring a claim?
No, my lord, we don't rely on the arbitration clause.
Or the adjudication clause?
No, my lord.
Sorry, why not?
Well, my lord, we are in court. We engage the issues. I think it would have been open to NH to say, look, the subject matter of this dispute is governed by an arbitration clause. Therefore, stay these proceedings and have this matter determined in arbitration.
I suppose the short point is that that's a point to take right at the outset.
Yes.
And it wasn't.
Yes, my lord.
But it might be said against you, well, that just shows the parties aren't strictly complying with all the terms of the contract.
Well, my lord, it might be said, but I think it's not unusual for a party to waive a provision, and certainly we'd be met with the argument that we waive that. But it can't be that if we waive one provision, we waive all. And that would be our response.
Well, I think what's been put against you and what you've so far said is that on the face of it, it may well be that a notice was served. In any event, there's indications that the parties are not strictly complying with FIDIC because they've waived at least the adjudication and mediation. There's no reason to think they might not have waived, therefore, other conditions.
Well, with respect, I think while it might be said, I think it's highly speculative and unfair. First of all, the Court of Appeal did not make any such finding.
But the strange thing about this case is that your side, as far as I can see from the transcripts of the Court of Appeal, didn't raise clause 20.1.
Well, my lord,
it was briefly mentioned by, oddly enough, it's one of the
Yes.
many oddities of the case,
Yes.
It was briefly mentioned by your opponent in the Court of Appeal, but for the purposes of a quite different submission.
I think I mentioned it in the Court of Appeal, perhaps not in the written submissions, my lord, but the reason why it wasn't mentioned in the Court of Appeal, my lord, is because in the Court of Appeal was not engaged in an adjudication of the contractual claims. The case which was being run by the other side in the Court of Appeal had nothing to do with these express provisions in the contract. The case which was being run was a restitutionary quantum merit and belatedly a contractual quantum merit. And the Court of Appeal was not, with respect, the battleground for this to happen. The appropriate place for this to have been canvassed was in the High Court, where the trial took place, and it only could have happened if NH was faced with a breach of contract case, which it was not. I'm conscious that I have only 20 minutes left,
Yes,
so
I'm
if
sorry,
you forgive me,
we've been
I'd like to move on.
answering your request.
Yes, right. I will try and make some of these points in shorter format than I had intended, but I will turn now to the pleading argument. And my submission on that is that the case advanced by Gordon Winter in the court below was advanced on an exclusive basis, restitutionary quantum merit, grounded in unjust enrichment. And I'll give you the references for your note.
I'm not sure that's necessarily in dispute, as so far as the pleading case is concerned.
Right, okay. Well, I will now, I will turn to the submissions as well. It was also Gordon Winter's position in its submissions at trial, and that's at page, in their principal submissions, they said no contract. That's paragraph 5B at page 2534 of the record.
Page 2534.
34.
Thank you.
Paragraph 10 at page 2539. Paragraph 80 at 2565. And in all of those paragraphs, they say in terms, no contract exists between the parties, and in answer to NH's counterclaim for breach of contract, it says there is no contract, and therefore NH can make no claim. Similarly, in Gordon Winter's High Court submissions and reply, at paragraph 5, which is at page 2627, and at paragraph 13, 2629, it also disavows any contract. And it says also in terms that its claim is exclusively in quantum merit, unjust enrichment, not contractual quantum merit. I'll turn up the references for that. It's in its High Court principal submissions, paragraph 1, at page 2532, where the opening line is, this is Gordon Winter's quantum merit claim in unjust enrichment. Paragraph 11, 2539, paragraph 14, 2541 of the record. And this is what it says there. The claimant relies upon this basic principle that its claim for unjust enrichment is not a claim for compensation for loss and is therefore not to be confused with a claim for contractual compensation. And again, at paragraph 70, 2561 of the record, and again at paragraph 74, 2563. And then in its High Court reply submissions, there are two other references. Paragraph 14A at page 2630, where it says its claim in quantum merit has its basis in the principle of unjust enrichment. And paragraph 22, the page number is 2632. Now, those references are important because it shows where the judge was led to make a determination and where NH's focus naturally had to be. You are being told consistently, don't meet a contractual quantum merit claim or any claim in contract. And against that foundation or backdrop, my lord, I respectfully submit that it can't be right for NH now to be interrogated before the board at the behest of the respondent to say, well, where are your contractual defenses? Right? It's simply unfair, is our submission. Because
but at every point, in response to this is an unjust enrichment claim, not a contract claim, your answer was, oh no, there's a contract.
Yes, my lord.
You might then say, well, it's hardly unfair on you if then you're pinned to the contract that you allege was there.
Well, my lord, that might be so, but a claim has to be made against us. There are cases in the reports where courts have repeatedly found that a party has made a claim on a unjust, on a restitutionary quantum merit basis and said, I'm sorry, there's no cause of action here because there is an express contract which deals with compensation. And we submit, why should the result be any different? This is not a case where the claimant was misled. The claimant knew the defense that was being run. And in the High Court, before the judge, didn't make any attempt to amend its pleadings, didn't submit differently. It was a high-risk strategy, and it should be held to that strategy now.
Can I just ask you this? Supposing the judge, well, in this case, of course, both the judge and the Court of Appeal held that there was a contract.
Yes,
that was your case. And made orders in your favour on that basis.
Yes, madam.
Supposing it was crystal clear that under the contract a sum of money was due to GW, absolutely crystal clear, couldn't be any doubt about it.
Yes,
would it be right for the court then to order you to pay that sum to GW?
I say no, my lord.
Why is that?
Because of party autonomy in terms of how cases are run. A classic example is the case of Almendi, which we cite in our authorities bundle. And I think that that decision was subsequently cited and with approval in a case of the board called Premio. And if I may summarize what that case, in my respectful submission, says, among other things.
Just forgive me, can you just give me the
reference?
in your written case, just know where this is.
I will pull it up here. It's in it is 3283 of the authorities bundle.
Right, hold on.
In particular, 3289, paragraph 21. And this is what is said there.
Just give me that paragraph again, sorry. Paragraph.
21, my lord,
21,
on page
thank you.
3289. And we say this is squarely what happened here. Right? In my view, this is from the judgment of the Court of Appeal, and this is a judgment of Lord Justice Dyson. In my view, the judge was not entitled to fine for the claimant on the basis of the third man theory. It is fundamental to our adversarial system of justice that the parties should clearly identify the issues that arise in the litigation, so that each has the opportunity of responding to the points made by the other. The function of the judge is to adjudicate on those issues alone. The parties may have their own reasons for limiting the issues or presenting them in a certain way. The judge can invite and even encourage the parties to recast or modify the issues. But if they refuse to do so, the judge must respect that decision. One consequence of this may be that the judge is compelled to reject a claim on the basis on which it was advanced, although he or she is of the opinion that it should have succeeded if it had been advanced on a different basis. Such an outcome may be unattractive, but any other approach leads to uncertainty and potentially real unfairness.
But here the issue as to whether there was a contract was squarely before the court, because that was your case.
Yes, my lord, but it was limited to whether a contract existed. It was not a case in which there was a claim for payment under a contract.
I thought you did make a claim for payment under the contract.
My lord, NH made a claim.
Yes.
Gordon Winter's position was there is no contract.
Yes, I see.
NH says, hold on, there is a contract. We have a counterclaim. This is our final account. Give us our remedy in contract. And why we rely on Almendi is we say Almendi is doing exactly what we say should not happen. It's identifying the problems with it. And it's precisely what happened in this case at the Court of Appeal. And when my lord, in answer to my lord's question, if you say to me, well, it might appear to the court that this money is due and owing, my answer is Almendi, because the claimant in this case chose, consistent with party autonomy, how the claimant was going to run its case. And while such an outcome might be unattractive, it is where the law, in our respectful submission, must take the claimant. The other point we make really turns on the question of election. And the point we make here is that by Gordon Winter electing to run the case the way it did in the High Court, both in the pleadings and its submissions, it foreclosed any possibility of running a case in the Court of Appeal, or pursuing an appeal for that matter, on the basis of the existence of any contract. Whether that be an express contract, a written contract which provides for payment in express terms through a mechanism, or whether it is in respect of a contractual quantum merit. And we say that position is supported by authority. there is a case in the authorities bundle. I can turn it up if you require me to, but as a matter of general principle, it says that no claim in unjust enrichment or restitution will lie when there's a subsisting contract, and that is the case of Michael Agiopis Dimandis. It's at page 3742. I think that's a fairly accepted principle, Malone. I don't think it's controversial. But an important case is the case of Zavodinik. I think I've got the pronunciation right.
Give us a page and then I'll be able to spell it.
Yes. And it is to be found at page 4016. It's a case out of the New South Wales Court of Appeal. And the relevant passage on which we rely is at page 4023.
This is Zavodnik and
Yes, it is.
Alex Constructions.
Yes, my lords. And if we can pick it up in at paragraph 31. This is what the Court of Appeal of New South Wales says. Nothing turns in this case on the distinction between a cause of action in contract and one in restitution. They are different, but as a matter of substance, in the present case, they are alternative and inconsistent remedies based on the same facts.
Sorry, I'm awfully sorry. Just give me the page number again.
4023,
4023. Sorry, I got the numbers wrong way around.
paragraph 31 of the judgment. Yes, they go on to say, because they are alternative and inconsistent, a plaintiff is not entitled to judgment on both. If there was an enforceable contract, there could be no recovery in restitution and vice versa. The principle is well established. And then they cite a case from the House of Lords. And then at 33, there can be a cause of action estoppel, as Troll Industries demonstrates, whether the plaintiff succeeds or fails in the first action. So what we say that authority is showing is that you have to make an election. And you make that election through to judgment, and you are stuck with it. And in this case, and I will come to another authority in a moment, in this case, we say that is precisely what happened. You can't change your mind in the Court of Appeal, and the Court of Appeal can't move the goalposts. There's another case we rely upon in the bundle. It's the case of Rukmin Balgobin, and that is at page 3920. It's a judgment of the board. And the relevant passage we rely upon is at paragraph 21 at page 3926 to 27. Now, there are a number of, perhaps interestingly, it can start at paragraph 18 and conclude at paragraph 21. But we say there are three principles or 3 points which emerge from that case. Is that the first is that the doctrine of election applies in mutually contradictory cases and in genuine alternative cases. And it applies, at paragraph 21, it applies where legal or factually inconsistent cases exist, and the reliance on one basis of a claim will prevent reliance on the other. Now, we accept that in this case, Lord Carr was dealing with there a situation where you had multiple defendants. But we say that there's no reason in principle why the doctrine should not equally apply.
face of it, 21 makes it look as if it's an election at the time you get a judgment in your favour,
It does, my lord.
rather than being held to have made some election if you only pursue one claim and simply lose on it, or an election at some earlier stage before judgment.
It is a point which I considered, my lord, but if my lord recalls the reference to the New South Wales Court of Appeal case, Zadvonik, I referred the board to paragraph 33 of that judgment at page 4023. The reference here admittedly is to an estoppel, but we say really in this case there's not much difference between the two in effect. And what they say there is that there can be a cause of action estoppel whether the plaintiff succeeds or fails in the first action. So we say...
It's a very short and terse statement.
Yeah, it seems to be based on an earlier Australian decision,
Yes,
first instance decision of Mr. Justice Gummo in a case called Trawl Industries.
It is, my lord, but our submission would be this. In principle, there ought not to be any difference as to whether judgment is given in your favor or not. Because the point is, you've run your case on one footing. There are potential inconsistent or contradictory cases. You make an election. You have to choose. You have to choose. And having made that choice, you are to be held to it. One might say it's sort of arguably akin to an abusive process to run your case right through the trial on one footing and then come in the Court of Appeal and say, well, hold on, hear me now on this case, after the main event has passed.
But if the only judgment in the case is that you are actually liable on the other side's contractual cross-claim, it's slightly odd that you're forever stopped from asserting that there was a contract.
But
Because the judgment, which was given by the judge in this case,
Yes.
the claimant had no claim. But
Yes.
the defendant had a whopping cross-claim for damages under the contract which the claimant had denied.
I accept that.
It's difficult to see how the claimant ends up being stopped from arguing that there was ever a contract when there's a judgment that there was one.
Well, perhaps the better basis to put it, my lord, is on the election footing as opposed to the estoppel. I accept that. There can be difficulties with that argument. But we say if one approaches it on election principles.
But election is normally, I think, election on a judgment. You can run inconsistent cases, but at the point of judgment, you have to go one way or the other. But of course, in this case, that couldn't arise because they didn't get a judgment.
Well, they didn't get a judgment in their favor.
Yes. Yeah.
My final point in the few moments that I have, my lord, I think I've dealt with most of this already, is on the question of unfairness. And it has been a theme throughout my submissions, right? And just to recap, NH didn't have an opportunity to plead any contractual defenses. That wasn't the case it was coming to meet. In fact, it would have been wrong for it to plead any contractual defenses in answer to a claim that it would have to speculate about. While NH did in fact assert a contract in its counterclaim, it was only required to do so in order to defeat the restitutionary claim. It wasn't called upon to deal with the contract in any other way. And it would have been able to interrogate a contractual claim and potentially plead defenses to it if Gordon Winter had in fact run that case. It didn't. And interestingly, when the case arises for the first time in the Court of Appeal, that is in 2023, after the claim was filed in 2006, well, if a claim had been run then, NH would have plainly had limitation defenses available to it. Many, many years after the fact, but by reason of the Court of Appeal's judgment, it can't run those defenses. So our submission is that in all those circumstances, the Court of Appeal's decision was wrong. We ask that it be set aside for the reasons I've identified to the board. And unless I can be of any further assistance, those are,
Did you say limitation defences?
Yes, my lord.
Yes, thank you. No, nothing further.
those are my
No, well,
submissions.
thank you very much, Mr. Benjamin.
My lord. My lords, can I give a quick answer to what my learned friend has said and by way of summary? And then, my lord, I would like to invite your attention to a few of the details in the record which contradict my learned friend's assertions. So we say, firstly, that there was no unfairness visited upon NH by the manner in which Gordon Winter ran its case at first instance and ultimately in the Court of Appeal. We fully accept that there is an element of untidiness about it, but it is clear beyond peradventure that the pleaded case sought recovery by Gordon Winter for the work that it said it had done and which NH accepted that it had done. Much more importantly, and omitted by my learned friend, at first instance, and I'm picking up a question from my Lord Richards as to an instance as to whether if there was an entitlement that was crystal clear, was the way that my Lord phrased it. And that's precisely what happened in this case. So that when you go to the last paragraphs of the learned judge's judgment, you will see that in reliance upon concessions made by the sole witness for NH, that certain payments had to be made to Gordon Winter, the learned judge, in reliance upon those concessions, both in the written witness statement and under cross-examination, said, based on these concessions, and that's her words, which I take to be a synonym of crystal clear, I will direct payments of these sums due to Gordon Winter. And my lord, if you want the reference for that, because I see you're leafing through the pages, can I just help you?
Please.
I can. I said it was the last couple of paragraphs. My lord, can I just ask you to, just for your note, if you,
Yep.
the paragraphs of analysis begin at paragraph 34 onwards. That's 244 onwards. I hope you have it in the key documents bundle. And the concession reference. Sorry, my lord.
I do the general trial bundle, not the...
Oh, I do apologize, my lord.
the
I made an
same
assumption. It doesn't matter.
Maybe the same
It's 245, and the concession paragraph is paragraph 37. And I will just read a single sentence to make good this observation. Nevertheless, and as conceded by the defendant, so my lords, I'm reading the second sentence from paragraph 37, there being variations to the contract not contemplated, including except pre-drilling, etc., the court must consider what, if any, sums are due to the claimant from the defendant under these variations. And thereafter, as my lords knows, if you look at the table, that I don't want to lose too much time. If you look at the table under paragraph 48 onwards, she sets out the sums that are due. And similarly, in the Court of Appeal, that language of concession is picked up and relied upon for the purpose of making a determination as to what sums, reasonable sums, are due by way of remuneration to the subcontractor. So we say, as the case was run at first instance, and as the evidence emerged, exactly as my Lord Richards, as it were, pithily captured by the phrase crystal clear. So these concessions were crystal clear. So secondly, we say that in the Court of Appeal, this is what we said to the Court of Appeal, very simply. If we are wrong that there is a contract, then we say we have a claim in contractual quantum merit, because what Gordon Winter seeks, as is reflected in its pleaded relief, is reasonable remuneration for the work that was done. And so that's how we put it. Up front, if you're wrong, we have a contractual contra merit, and in due course I'll give my lord the page references to me saying that in my oral submissions. My lords, you have heard a great deal, this is my third introductory point before I come to some facts, you've heard a great deal about the FIDIC terms. But you will struggle to find in the record any cross-examination about those FIDIC terms, any discussion about those FIDIC terms. In fact, you will struggle to find in the correspondence any reliance upon the FIDIC terms that my learned friend says he has discovered quite important. So he relies upon 12.3, he relies upon 20, and he relies upon, I think is it 412?
Yes.
412. Well, my lord, just using 412 as an entry point, can I just invite your attention to 3 letters in the record of appeal, in the papers before you, which pass between the parties, which demonstrate that they were alive to the issues of ground conditions or unforeseen conditions and notice. So, my lord, I'm doing 2 things at the same time. Can I ask you, my lords, firstly, if you could look at page 719 of the record. That is a letter dated the 19th of April, 2006. And if my lords have it, as soon as you get it, I will, it's a single page, so we'll be quick about it. And my lord, just so that you have context, and I don't think this is controversial, the context of this letter is that the contract having begun its execution at the end of 2005, beginning of 2006, there were extensive investigations as to ground conditions. Put shortly, the 5,000 PSI per square inch piles were proving to be very difficult to penetrate the ground. A series of contractors, both local and international, were brought in to try to identify what the problem was. So that's part of this context. As discussed during yesterday's meeting at UDGOD office, we accept your proposal to install pre-augured 5,000 PSI piles. Just pausing there, I'm sure my lords have picked up that one of the solutions to the difficulty of driving piles of whatever strength, 5,000, 6,005, 7,000, 8,000, was to pre-auger, which is basically to drill a hole into the ground and then to hammer the pile in. So that's what this is talking about. And so that is really the context of the variations that were directed. Now, as your subcontractor, my lord, I'm going to the second paragraph, Gordon Winter, had agreed during that meeting, he will accept liability in the consequences for any pile breaks of 5,000 PSI, excepting unforeseen physical conditions. So in other words, my lord, there was an identification of the issue. It's not a question of just treating the issue in the abstract, and we therefore confirm your acceptance of the same. And then finally, as discussed during the meeting, it was our intention to instruct the installation of pre-augured 6,000 PSI piles. So this is a different specification from that which was the base specification in the contract that was signed or that was agreed between the parties in November or December of the previous year. And then you will see in the very last line of that paragraph, 7,000 PSA piles, which is really well underway by your supplier, Presticon. Those piles should be installed with a pre-auger in lieu of the 6,000 PSI strength piles. So well, that's just one letter indicating an awareness not only of the variations directed by the engineer, because that's who Turner Alpha is. They're the project manager, they're acting as engineer. They're directing what needs to be done, A, to the main contractor, and of course, this can only be executed by the subcontractor. So just pausing there, the notion that we had to apply doesn't arise. So my Lord Bowers put to my learned friend, well, hold on, were these many FIDIC terms being complied with strictly? The answer is they were not, and this is simply an illustration of Turner Alpha giving a direction which was complied with and therefore gives rise to an entitlement. It's not a question of was there an issue or question over it? Can I invite my Lord's attention to page 721? This is a letter that's dated 2 days afterwards, on the 21st of April. And it's in response, or part of the same matrix. Further to our meetings yesterday and today, we confirm our instruction. And my Lord, this is important because you're seeing the chain. This is, of course, a letter going from the main contractor, NH, to Gordon Winter. We hereby confirm our instruction for you to immediately proceed with the pre-augering and piling of 5,000 PSI piles to the center core and northern section, and 6,000 PSI piles to the southern section, all as discussed. So just pausing there, all of the letters are doing are recording the oral instruction, and they are entirely consistent with the direction being given from the main contractor to the subcontractor. We also confirm our instruction to you to immediately commence the manufacture of sufficient 5,500 piles to be used in the center core on the northern section of the site. Exact quantities to be confirmed. And then the next sentence is important because that's why we're here. The sole reason why we are in this court before my Lord's board is the next sentence. Final cost to be agreed in due course. And I'll have a submission to make about measurement or absence of measurement in a minute. But you can see that what the parties were doing were debating and talking about agreement. Not about measurement, agreement. And in the meeting today, we discussed other things. And my Lord, I just wanted this, the next line is, will give you a flavor of the correspondence that took place between the parties in May, which I'm going to ask my Lords to be patient with me and let me spend some time on. In the meeting today, we have discussed the delay costs, and currently we are only looking to receive recovery of 6 weeks of costs out of a delay period to date of 10 weeks. So the parties are alive to the fact that the contract is behind time, precisely because it was proving difficult, if not impossible, for the 5,000 PSI piles to penetrate the ground. And so you know what the solution is. Augering, 1, 2, an increase in the strength of the piles, and that is what Gordon Winters makes his claim in respect of. My Lords, can I invite your attention to the very letter my Lord Richards anticipated that we would be talking about, and my friend has said nothing about. That's on page 724. It's a letter dated incongruously the 31st of April, 2006. And it's from Gordon Winter. So you're hearing now from my client. They're acknowledging the email, if my Lords are with me, 724. It's our understanding for these meetings that this instruction is based upon the following variations to the scope. Northern area, and I'm not going to read it all out, but you can see the areas, 5,500 PSA piles, central area, 5,005. And my Lord, it's important, those are departures from the specifications. South area, 6,600 PSI piles, etc. For each of the above, a unit rate has been provided for your consideration and approval. Based upon the scope, because there was a complaint about no notice, based upon the scope, we have reviewed and attached the baseline schedule for your information. The manufacturing and installation revised finished dates are summarized as follows, and the 2 delay periods are given. Manufacturing, 71 days. Unfortunately, I can't quite make out installation. I think it's 95 days. And these are delays from the original period. Over the page. It's our understanding that the following additional items are not resolved nor agreed. Schedule delay, non-compliance, specialist, etc. And my Lord, I'm not going to ask you to read the impossible fine print on the pages that follow, which is 726 and so on. But what you will see, my Lord, if you go to 727, is the base quote of 3.4 million. You should recognize it from the pleaded case. And then over the page, it's an identification of what is to be done under the different scenarios. That's at 728 and so on, my Lord. 728, 729, etc. So what I say about that is as follows. Precisely as my Lord Richards anticipated, or recognized, if I could put it like this, like that, that my learned friend has come to the board to complain that, well, I didn't get notice, but the record and I've only given you 3 instances, is replete with instances going back to February of 2006. That's my pleaded case. That letter is as part of my pleading, all the way to almost the very end of April, beginning of May, a series of instructions being given to my client, Gordon Winter, to carry out work which was over and above that which it had originally contracted to, indicating 2 things. We've sent you the prices, and there are scheduling or timetabling consequences. So the notion that there was no notice was not an issue in the case at all. It was not an issue in the case at all. And so for my little friend to come before the board and suggest that it might have been a contractual offense is, with respect, a suggestion entirely without substance, or at very least contrary to the records before my lord. My lords, while I'm...
So can I just be
Yes, my lord, please.
clear?
Yes.
Are you saying that the parties were not strictly complying with the FIDIC terms, but they were clearly responding to the changed circumstances with letters going between them, making quite clear what was required?
That's precisely what I'm saying, my lord. And I want to make it clear in this sense. So there was no question, and my learned friend has not invited your attention to any document in respect of which there was any measurement. So 12.3, I wouldn't go so far as to suggest that 12.3 is written water, because that will be an overstatement, and I'll be guilty of the sort of forensic hyperbole that got me into trouble before the High Court. But I would say this: there was nothing in it. There was no suggestion that there had to be measurement. What happened in this case was that prices were put forward, and then, my lord, those prices were used as a basis by NH to negotiate with its client. It added its markup onto those prices. It then engaged in negotiations for an extension of time, got the extension, and managed to extract from Udicot, the ultimate client, and Turner Alpha, and I'm going to show you the letter in a moment, dated the 9th of May 2006, in respect of which, that's a page, in respect of which, it's 1110, in respect of which the sum that was agreed to be paid by Udicot to NH was $3.9 million, out of which the agreement between those 2 parties, payment was to be made to Gordon Winter. So let me make good on that suggestion now, if I may, my lords. Just want to make sure I have the right document in front of me. Lords, can I ask my lords to go to page 1110, 1110. Do my lords have it?
Yes.
Yes, my lord?
Yes, thank you.
So this is a letter, again, to remember we started with Turner Alpha. They're the project manager, they're the engineer under the main contract. They're writing to NH. We refer to your letter dated the 5th of May. Apologize for not having responded sooner, regarding confirmation of the agreement. As you are aware, we were first awaiting the employer's formal ratification. We confirmed the employer's without prejudice approval of the agreement reached between ourselves during the meeting of the 26th of April. So, my Lord Richard, that's an important fact, because prior to the writing of the letter dated the 31st of April, there had been agreement arrived at the level of the main contractor and its client. The elements of that agreement are as follows. NH shall receive an extension of time for completion of the works, 10 weeks. That's the entirety of the works, but we know at this stage the only thing that has occurred is the foundation material work. 2, NH shall receive an additional payment of $3.9 million, exactly as I said, in accordance with the attached schedule, and I'll come to the schedule in a second, to complete the piling. So any ambiguity as to what that payment was for is resolved, and to rectify defective piling work using an alternative method. In other words, my lord, the use of the continuous flight auger to make a pre-boring through a hard layer, so that's the difficult conditions, and then put the pile into the pre-bored hole and drive it. The amount allows for all additional payments that NH must make to their specialist piling contractor, Gordon Winter. So here is the principal saying, I'm signing off on this agreement, and this is who these monies are for. And my lord, I'm not going to bother to read, if I may, paragraphs 3 and 4. I just want to take you over the page. Because my lord, Lord Burrows asked the question, well, what about compliance? All installed piles shall not be remeasured. My lord, I'm on paragraph 6. Notwithstanding variations from the installation depths. So that's another indication that there is no need for remeasurement. And I won't bother to read 7 and 8. Can I go now, please, to the schedule at page 1112? And there is a breakdown of the sum. It's divided into two parts. Simply, there's a northern section of 1.2 million, if my lords are with me, all involving drilling, etc., driving costs, and so on. And my lord, in brackets, I say, and I'm not going to take you to it, when you go back to look at the learned judge's judgment, you will see in the following paragraphs after 37, these are the things that she took into account, because this work was done. Auguring under the 2 levels of PSI, delay cost, staff, plant, GW overhead, so they're specifically identified as a line item, and then it's 7 weeks with cost, $1.15 million. There's an element for delay, and the total amount is 3.9. So what we say about that is as follows, my lord, that what the parties were doing, they were agreeing at the level of the client and the main contractor what the cost consequences were as between them in respect of piling works to be carried out by my client. But in respect of when it came to NH dealing with my client, as my learned friend has accepted, there was no such agreement. And so you have this oddity whereby what happens is my client provides a cost, NH adds a markup to it, submits it to Turner Alpha for the approval of their client. That is accepted and approved, but when it comes to determining whether they will agree the much lesser sum, or significantly lesser sum, because there's no markup, with Gordon Winter, nothing happens. And so, my lord, that's what Lord Bowles, that's my answer to my lord's question. There was no agreement. And it was not for Gordon Winter to do anything. It's fundamental. They had done all that was required of them. They were required to do 2 things. Find an engineering solution to the problem and tell their main contractor what it cost. The contractor's response was, Gordon Winter, get on with the work, but you will not be paid. And the facts are, in this case, that there was no payment to Gordon Winter after the 28th of February 2006. And that's why I'm showing you correspondence that passed between the parties in April and May of that year, and therefore it could be no surprise that when it comes to the end of June, having said to NH by letter dated the 17th of May, I'm not going to take you to it in the interest of time, by letter dated the 17th of May, you have not agreed, and if you don't agree within the next 2 weeks, we have no choice but to leave the site. The learned judge down below felt it was open to her to find that amounted to an abandonment or repudiatory breach because it didn't strictly comply with FIDIC. I have not appealed against it. I can't complain about it. The only relief I got in the Court of Appeal was that the level of damages was reduced, and I'm going to leave that there. So, my lords, can I come back now to responding to what my learned friend has to say in relation to unfairness? But before I do that, please permit me to say one more sentence about unfairness. If anyone could come to this board and say on the record that I have been treated unfairly, it is not the appellant. It could only be Gordon Winter. I promised before a moment ago to give you an indication in my oral submissions as to where I made clear to the Court of Appeal that if they were against me on my principal case, and I think one instance of doing so is to be found on 2962. I have several, but can I just give you one?
2962.
2962. And as my Lord Briggs indicated, that's the transcript. And I suspect my Lord has read it already. And can I just pick it up? Can I just pick it up from line 5? Just to make two connected points. So does my Lord see Justice of Appeal Barrow? This acceptance by Mr. Williams, and that's a reference to the concession that's to be found in his witness statement. I didn't give you the paragraphs in his witness statement. Can I do so now? They are paragraphs 31 and 39. But this is an acceptance. They accepted that Williams did, in fact, did the work. Yes, of course. That GW did the work. They did, in fact. And then just going a couple of lines down, yes, whether it is, and this is in spite of their being on the basis of a contract. That's Justice Barrow putting the question to me. Yes, my Lord, I respond. Their case is on the basis of a contract. Yes, my Lords. Okay, all right. And can I say this? Your point, and this is where they pick it up, your point is contract or no contract, quantum merit. And all I'm doing there, my Lords, is saying, I hope, consistently with, but not in anticipation, and in anticipation of, what my Lords had to say in the case of Barton. I think it was my Lord Burroughs who made it very clear in Barton that quantum merit is a slightly tricky concept because it disguises the fact that there are two, I suppose, causes of action is how my friend would want to express it. There's a contractual quantum merit, and then there is an unjust enrichment or restitutionary quantum merit. And the cases, as my Lord knows, the cases are replete with cases on the one side or the other. In fact, in the bundle, we have several cases, and there are instances all in the context of construction contracts. So without asking you to go to the bundle of authorities, there's a case called CERC, in respect of which the quantum merit that was upheld in that case was one of an unjust enrichment nature. That's to be found at tab 18, page 3950. You don't need to go to it. I'm just giving it to you as an illustration. And there's another case of Brunel, ERDC against Brunel, to be found at 3621. Those are two cases on either side of the quantum merit divide, if I can call it that. One being contractual, one being unjust enrichment. CERC is the unjust enrichment one, and Brunel is the instance of contractual quantum merit. And my Lords, I would add that both of those decisions are decided by very distinguished members of the Technology Court who deal with these kinds of matters on a day-in, day-out basis. So this is what I have to say about my friend's argument about alternative and inconsistent causes of action. He has not cited, because he can't, a single construction case, we say, that makes the point in the way that he wants to, i.e., that says, in a case where the parties are arguing as to whether or not there is a contract, and one party says there isn't, as happened in this case, and another party says that there is, it is not inconsistent, we say, and those cases are supportive of that, it is not inconsistent we say, to suggest that it is open to the contractor to say, I am entitled to a contractual quantum merit, because all that is doing is allowing the court to determine reasonable remuneration in the absence of agreement. And that's the principle with respect. It is not, the principle is not that in the absence of the use of a mechanism that might have been available to the parties and in respect of which on the evidence they did not use, because that's the evidence, that there was no use of the 12.3 mechanism by NH, and that is why I took you to the correspondence first, because all that NH was required to do was to indicate to what price were they agreeing. And there was no indication whatsoever. None at all. And so we say that all of the, how do I put this politely, rather belated appeal to 12.3 and other provisions. I've dealt with notice already. I've dealt with the unforeseen conditions. I want to dispose of 12.3 now. The rather belated appeal to 12.3 and say that there's a mechanism without inviting the board's attention to a single instance or a single line or a single letter in respect of which it might have been said to have been invoked is also, we say, with great respect, writ in water. My lords, I think I have dealt with my learned friend by reference to a whole number of paragraphs in my written submissions at first instance said, or rather asserted, that I disavowed the contract. I own that. I say with respect that my position simply was, we said that there was no contract. We fully undertook a case in respect of which we sought to persuade unsuccessfully the Court of Appeal that there was no contract, at the same time seeking to resist a claim for contractual damages against us. So the notion that really underlies my learned friend's submissions, that contract wasn't part of trial agenda, if I could put it like that, is simply without substance. Because it doesn't matter, with respect, as far as the judge is concerned, or as far as the Court of Appeal is concerned, who raises what. What matters, in answer to his reliance upon all of the authorities that talk about inconsistency and talk about the third man theory, what matters is what was the trial agenda? What were the issues before the court? And if one were to pose the rhetorical question, was the existence of a contract and the terms upon which that contract consisted of, and whether or not work was done pursuant to that contract, and whether prices were agreed or not, those were the essence, that was the essence of the trial agenda. And there is nothing that my learned friend can say to get away from that. He has sought, we say unsuccessfully, to bifurcate those issues into, well, really it was for the respondent to make clear in their pleading alternative courses of action and so on. We say that's not the way to look at it. That when you analyze the cases, whether you go to the Court of Appeal of New South Wales, or whether you look at a first instance judge, or whether you go to Lord Justice Dyson, that the outcome is the same. In other words, was there clarity as to what the issues were? And we say there was no lack of clarity, and therefore no unfairness. And we say, in any event, every single submission made by my learned friend to the board today could have been advanced to the Court of Appeal in September and October of 2022, and was not. And that is why I put in my written case, one of the issues for the board to determine is whether or not my friend can raise the issue at this stage. Yes, he has astutely, no disrespect intended, dressed it up as an issue of law and pleading, but was it something that he could not have said to the Court of Appeal in respect of, in trying to persuade them that they ought not to do the two things that they did. The first thing that they did was that they overturned the judge's finding that we had been in breach by way of poor workmanship. And so the whopping damages that my Lord Briggs referred to, with the exception of the level of damages for repudiatory breach, wrongful termination, but that millions of dollars worth of damages was set aside, and quite properly so. So clearly, the agenda for the Court of Appeal was a contractual one. I'm trying my best to avoid the use of the word quasi-contract in deference to my former law teacher, Professor Jones. But secondly, and very, very importantly, the Court of Appeal also determined the question as to what was Gordon Winter's entitlement. And my Lord, it's important that you understand, because you haven't been told by my learned friend, part of the way in which that was done. I'm not going to take you to the details, but for the benefit of the Court of Appeal, we prepared a Scott schedule in respect of which the parties said, this is the sum that I claim, and that is to say, I said it as the respondent, and my learned friend for the other side said, either I accept it or I dispute it. And in that schedule, yet again, there were, consistent with the witness statement of Mr. John Williams, as well as other evidence in the record of the case, a number of concessions. A number of concessions, my Lord. These are further instances in respect of which, and we say that my Lord Richards' characterization is absolutely correct, that what the Court of Appeal was doing was saying, in relation to 6 or 7 different heads of damage, this is something that's accepted by the other side, and we award it. To the extent that it's in dispute as to quantum, not as to entitlement, we send it for assessment.
Just help me. I haven't looked at the Scott schedule.
Yes.
Was this something which both sides participated?
Yes, my Lord.
Can we look at
Absolutely, my Lord.
a typical
Just
bit of it?
make sure that I get it. I think we annexed it to this SFI. I think we did, my Lord. My Lord, so if you go, I think we did it. Just 1 second, my Lord. I just want to make sure that my memory is 3215 is what I'm being reminded. Just looking for my hard copy.
Yeah.
Yes.
Oh, so the Court of Appeal made an order
I'm sorry,
for
my
the
Lord.
Scott schedule.
My Lord, could you put that question to me again? I didn't hear everything, my
It
Lord.
looks as if the Court of Appeal made an order for us.
Yes. So, my Lord, just a single sentence on it. I don't know how I'm doing for time. The single sentence is this, that the Court of Appeal said to us, look, it appears to us that there is going to be some remaining dispute about absolute quantum. In order to assist us in this plethora of paper, will the parties try to agree a document in respect of which they set out their positions? We went a little bit further because of the length of Mr. Jardine's witness statement and the number of annexures, and tried to also give a steer to what was in the record. And I just want to give you an instance, my Lord. So if my Lord goes to page 3217, and I hope you have it, 3217, and this is the point that I was making. Is my Lord with me there, where you see a figure $1.2 million? The print is tiny, so I apologize for that. But if my Lord is with me, please.
Yes.
Yes. And my Lord, it's important to look at what the respondent's position was. The respondent's position, the respondent agrees the sum of, and then that figure is repeated in the far right-hand corner. And so, my Lord, I'm simply giving that, and there's probably one other instance I can give you. If you go to page 3220, and there's another item, it's for the sum of $266,000. And the respondent's position is the respondent agrees the sum of $266,000. And I'm merely giving my Lord those instances of agreement because in answer, or picking up, if I may say with respect and with gratitude, what my Lord Burroughs and Lord Richards have said, where there are instances in respect of which either the amount are crystal clear or the only thing is to have a dive into whether there were 27 piles as opposed to 20 or 28, or a question as to whether or not there was 800 hours on standby as opposed to 750, and that needs to go for assessment. But everything else, and you will see in each instance, the Court of Appeal gave a very clear and unequivocal decision.
Sometimes Scott schedules are completed, as it were, subject to some overarching general objection that none of it's recoverable, but subject to that we agree the following figures.
Yes.
I don't know what the Court of Appeal's order about this Scott schedule said, and I don't know whether the respondent's contribution to it was the respondent in the Court of Appeal's contribution
the appellant.
to it, was, as it were, hedged about with those sorts of reservations.
My Lord, I will answer, and maybe my friend in reply will have his own version. So I will tell you factually what happened. I did a draft, sent it to my friend.
Is the Court of Appeal's order in the bundle? Scott schedule order?
I don't think it is, my Lord.
Okay.
I'm pretty certain it's not. In other words, my Lord, in fact, I don't even know. I'm not even sure if I would describe it as an order in the strict sense. They were very strict about when they would get it. They didn't get it until after the appeal actually was completed all submissions, and I got into a lot of trouble with the court for that. But we volunteered it as a means of easing the burden that they would otherwise have to undertake. And my Lord is very well familiar with judgments in the technology court, technology and construction court. You have...
Don't make any wild assumptions, Mr. Benjamin,
my Lord,
about how familiar we all are with what goes on in this business.
Well, my Lord, let me do it this way. If you use the cases that I've put into the bundle as an illustration, those judgments are characterized in this way, and this is just a simple sentence. You might have an 80-page judgment. 40 of it is resolving what I might call the contractual issues,
Yeah.
and the other 30, 40 pages, it's a detailed analysis based on the schedules as to what the court is and is not allowing. In this instance, the Court of Appeal said, okay, you don't have agreement, we'll send it for assessment unless it's expressly agreed.
So this was all ordered at the hearing?
Yes.
Provided after the hearing?
Correct. As a means of reducing the amount of time.
Can I just ask you this?
Yes.
It's slightly taking us out of where we've now got to, but nevertheless.
No, Lord,
The Court of Appeal order,
yes.
really we're dealing with just two paragraphs of that, as I understand it, two of the orders. That's Order 2 and Order 6.
Yes.
Order 2 is all about standby,
Yes.
which, as I understand it, is not performing work as such, but the fact that one is standing by with all the equipment and men and so on in a situation where there's been some delay or something of that kind. But all I was...
Yes,
I mean,
yes.
Correct me if I'm wrong, but can I just finish my
Yes,
my
of
question?
course.
But then there's Order 6,
And look, would you mind just giving me the page reference? Because I'm thinking about what you're saying.
339.
339.
This is the court order. As I understood it, we're dealing... The appeal is only on 2 and 6 of the order.
Yes.
So are most of the claims that you are now seeking payment on caught by Order 6, which is the reference to Document 64? And I don't know what Document 64 is.
So no, the reference to Document 64 is a reference to a document in the High Court bundle, in respect of which there was a claim. In other words, my Lord, you remember I showed you some correspondence from April in which there was a detailed set. So it's a version of that. Right. In other words, it's a version in respect of which Gordon Winter had sent to NH, this is where I think we are at, and that document came into being after the departure from site, and they said to them, listen, this is what you owe me.
Right.
And this is the basis for it. A line-by-line itemization in the way that I was trying to describe.
Right. So that covers a lot of the work. Is that right?
It does.
Yeah.
It does, but yes, I'm a lot.
Okay. So is the Order 2 about standby sort of just an additional tack on to Order 6?
Two things. It is significant, and significant in terms of the sums. So that's the first comment I would make. But secondly, my lord, I don't accept my learned friend's analysis of standby. Standby is not about delay. So the bill of quantities, and I'm going to struggle to find the page, but the bill of quantities specifically provides for standby. And you only understand what that means when you appreciate what the elements of the contract. In other words, what was required to be done by Gordon Winter. So Gordon Winter was required to do the following things. First of all, they had to manufacture the piles. Secondly, they had to transport those piles to the location. Thirdly, those piles were then subject to two different kinds of testing. So you produce a test pile, and you subject that pile to what's called a static test. That's you just put a weight on it, and you see how it stands up. And in the meantime, your staff are waiting, literally. They're standing by. So there is no active work going on, but it is an important part of the process for integrity. The second kind of testing that happens is dynamic testing, where specialist engineers come and they apply equipment to, and they hammer the pile, and they determine its integrity by what the readings on the equipment shows. And in the same instance, the crane driver and the other people are on standby while that is going on. So it is not that they are not working, they are literally standing by while others do their work, because testing is a vital part of the integrity of the process, because of course you're talking about a foundation for a building. So that's what standing by means in the initial context. And then the last element of standing by, of course, occurs when there's auguring. In other words, if I am drilling over here, then the fellow who is waiting to either switch over the crane and do the hammering, he's also standing by. He can't be called because otherwise there'll be a delay. So that's why it's broken down into standby auguring, standby piling, standby static testing. I hope that helps, my lord.
Yes, but have you received payment for the auguring, for the piling, for the static testing?
No, my lord.
It is non-standby.
My lord, can I just make this abundantly clear? We've received payment for NOTHING, nothing.
Right.
We have not received anything.
And where are you getting that under this order?
Where am I getting what, my lord?
Sorry, the order of the Court of Appeal, are you getting that
Yes.
under Order 2
Yes.
or under Order 6?
I'm getting my standby money, if I can call it that, under Order 2.
Right.
Right? The appeal is allowed and the contempt is referred to a master. So that's what I'm getting there. In other words, because there was a fight between us or among us or whatever the correct description is as to what constituted standby, the Court of Appeal, in a sense, segmented it out and looked at it as a group. Whereas looking at manufacturing, piling, auguring, that all came under 6, sorry, below.
Sorry, what came under 6?
Manufacturing,
Piling and auguring.
piling, auguring. I'm being besieged now with with bits of paper. My lord, just for your reference, I think the standby, I did say that the standby is provided for in the bill of quantities. My little junior, Mr. McQuilkin, who is not physically with me, because that was a visa problem, and I'm going to ask my lords to continue to be as helpful as you have been in the past. He didn't have the presence of mind to tell me he had a problem, so I couldn't appeal to the registrar. It's one of those things. The pages are 364 and 365. In other words, in the bill of quantities, standby is provided for and the rate is provided for. And then, my lords, I'm being told by those who, again by Mr. McQuilkin, to ask you to look at page 3112, and I just think that's the Scott schedule. I hope that it is. Oh, the order, in fact, the Scott schedule, probably. Yes. 312. It's really just references in the record or in the transcript. So 312 and 3113, simply saying about the Scott schedule. But can I just invite your attention because it helps me make another point?
31, just give me that again.
Yes, I was 3112, line 49.
3112.
Right?
Just give me a moment. Is this where they ask about the Scott schedule?
Well, it is where we are, I think Mr. Mutu is saying something to the court about it. Page 39, which is Schedule 1, where we reconcile the figures. You will see, we give credit for that. in the 660,000. And my Lord, I drew your attention to that. Do my Lord remember? I gave you two instances in the schedule where the sums were agreed. This is the second of the two and the lesser of the two. You will see we give credit for that 660,000 as having been due and applied as against monies paid. In other words, at that point in time, Mr. Mutu is still arguing, trying to hold on to the judgment of the counterclaim in his favor. So he's saying, well, I give credit for it. And that's the point that my Lord, that I say is crystal clear. And then over the page, you will see Mr. Mutu, Judges of Appeal, Mr. Mutu, I understood Mr. Benjamin yesterday, promised to provide something like a Scott Kiadu. It would have clarified the point and so on, my Lord. So strictly speaking, my Lord, I don't recall that there being an order. We undertook to do it, provide it to the court, and it was done, and that's why it's in the papers. My Lord, I don't know how I'm doing for time, but I do want to say something about, make sure I say something about election and estoppel, to the extent that I haven't already covered it, and then I will try to answer what I say on my friend 4 points. My short sentence on whether it's election or estoppel or anything of the sort is to say, with the greatest respect, there's nothing in the point at all. And I think I was getting there a moment ago. None of my little friend's authorities support the suggestion that he has made for the course that he took in this case. So, again, I ran a case on unjust enrichment quantum merit. I was unsuccessful. I went to the Court of Appeal and said, if you're against me, then contractual quantum merit. At no point in time, in answer to those submissions that I made orally, did my little friend say, estoppel, election, or any of the esoteric points that he's brought before my board. So that is why you do not have any consideration from the Court of Appeal on any of those points, because they were not taken, and we say it is far too late.
Well, I'm sorry.
And apart from that,
this, because your case in front of the Court of Appeal was there is no contract.
my case in front.
It's an unjust enrichment quantum merit.
My case in front of the Court of Appeal was in the alternative, my lord.
Well, where do we see that?
Yes. Let me take you to.
We see that reflected in what Justice of Appeal Barrow said to you in that passage.
Yes, and I could find 5
You
other.
say it's quantum merit, whether it's contractual or
Correct.
restitution.
Yes.
But I mean,
And you see it reflected in the judgment in the Court of Appeal, because they say exactly that.
But I mean that intervention or the question to you, what was that prompted by?
It was prompted by me. It was prompted by me saying to the Court of Appeal exactly what I've just said to my lords, that if you are, it wasn't prompted.
Well, what you? I mean, you gave us one very, very brief sort of question from the bench on your answer.
Yes. Let me see if I could find it. Who's the first?
I think I did take a note of where that was.
My lord.
Oh, 2962, I think.
I was taking my laws to 2962, but I have other references. Can I just see if I could find them? They are all in that vicinity.
And what I'm looking for really is that you're making it clear to the court that you're running alternative cases. One on quantum merit, but one on the basis that there is a contract.
My lord, yes. My lord, so can I take you back? I'm going to try to find the page, but I'm going to do this from memory, because early in my submissions, so that the reference that you've been given is a reference to what I said at the almost to the end of the day. Let me see if I can find a couple of instances earlier on. let me see, my lord, can I invite your attention to 2926 to start off with?
2926, you say?
Yes, 2926. And it began, my Lord Richards asked the question, well, how do we get there? I'm on line 33. Justice Repeal Rajkumar has asked me, or line 29. You see, the reason, Mr. Benjamin, I keep harping on the question of whether there's a contract under the contract. Yes, my Lord, because it sets a framework of how the analysis goes forward. My Lord, but even if the end result is that the quantum is still reimbursable, how do you get there slightly different in each case? And so, my Lord, that's his acknowledgement that there was a different approach from whether or not one goes with unjust enrichment or whether one is running a case on contractual quantum merit. And that I picked up.
You're relying, therefore, on your answers, your agreement to points put to you by.
I am in part. I'm also relying. I'm going to ask Ms.
but-
Budu to do a search. Use the words quantum merit. My Lord, can I?
It's the way you put your case I'm particularly interested in, rather than just how you respond to questions from the bench.
Yes. So, my Lord, can I tell you what I said, and then I'll just try to find, or would you prefer me just to find it in the?
Well, I'd really like to you to
Yes.
find it, but because otherwise we're clearly going to need to have the transcript references.
Okay, my Lord. I think I found something that's slightly more helpful. Can I ask you to go to 2893? And when my lords are with me, I'll take it from there. Is my lord with me? 2893?
Yes, I'm there.
Yes? My lord, in my respectful view, I'm on from line 21. The notice of appeal that we filed advances an argument in relation to whether there exists a contractual relationship between the parties. That's one, and to which it gives the answer in the negative and says the learned judge was wrong in her application of the principles. And we go further. We say that in her conclusion, she doesn't actually attend to the details. Line 34. In the alternative, we say that even if we are wrong, we claim a quantum merit. In other words, our position is whether there was a contractual relationship or not, and the court will have that which the learned judge did not do, which is to identify what terms are at play. And I continue, even if there's a relationship or not, we say, I'm on line 46, we say we are entitled to a quantum merit. Is my lord with me so far?
I am.
And then his lordship, Justice of Appeal Bearer, who was the presiding officer, the president of the tribunal, says whether or not irrespective, so even if there was a contract, and I respond, even if there's a contract, you're entitled to quantum merit, even if there's a contract. You're still entitled. We say that they're entitled to a quantum merit. Either way, you could put the quantum merit in yet further alternative by saying, contractually, if there was a contract, we are entitled to reasonable remuneration for the services provided. So either way, the appellant is entitled to an award. And below there are other references. I can give them to you. There's another one down at the bottom. Full contract and so on. Over the
Yeah, I see.
But Lord, I ended up, so what I showed you in the first instance, the first reference, which was way down on page 77, and my Lord, can you just note, if by looking at the fine print number on the bottom, this is early on this is my opening the appeal.
Yes.
Right, so I opened the appeal on the basis, and I also put the alternative in, by the way, in my written submissions. I think it's page 2757 of the record. So that my position was, from the beginning of my appeal, and this is the point that I was making, from the beginning of my appeal, on the basis factually that we'd been told to do this additional work.
Sorry, the page in your submissions was.
I think it was
Paragraph 97.
97,
You're
25.
quoting from Taylor and Bale.
Yes, that's it, Malone. And there was another case that I cited as well.
But how does that help you? Sorry.
No, my lord, it is simply an instance in respect of which the extract, if I'm not mistaken, my lord, because I haven't gone to the page, puts quantum merit in the two alternative ways in which Lord Burroughs and other members of the board of the Supreme Court in Barton made absolutely clear. And to be fair, my lords, I think there is a similar reference in...
I'm not sure you get it in paragraph 97.
I'm obliged, my lord. I'm doing
The
it
citation there would be rather against you.
Yeah, fair enough, my lord. But my lord, in any event, I would say that to the extent that going back as far as the Benedetti and Suarez case, which I think is 2013, I don't know if it's in the bundle. I don't think it is. Yes, it is.
It's really a question of how you put your case to the Court of Appeal.
Yeah, and my lord, that's it. I mean, I put my case in the alternative because the authorities made it clear that in a way that my pleading did not, that quantum merit as a portmanteau term applies to these two distinct and related causes of action. One, in contractual quantum merit, well established with the authorities, well known to all contract lawyers, and unjust enrichment, in respect of which the analysis and the lens is very, very different. As my lord, I think said, or this board has said in the Sumandar case, no, the Citridi salvage case, that distinction is made absolutely clear. Which I think, my recollection is that my Lord Burroughs gave the leading judgment in that case. I'll see if I'm correct. Yes. And so what we say is that when you look through the authorities, whether you go back to Benedetti, whether you stop at Barton, a very interesting case, my lords, in respect of which many observations have been made by learned commentators. But the one thing that there is no dispute in the authorities is that these are related causes of action that don't fall into the category, we say with respect, in the construction context, and this is quite important. And just picking up a line from Barton, I think that even though that was a 3-2 decision, there was no real dispute between members of the court as to what the underlying principles are. So I would say as follows, that one of the underlying principles is that as far as quantum merit is concerned, it is both a contractual cause of action as well as an unjust enrichment cause of action. That's number one. Number two, to the extent that the contractual quantum merit claim depends upon an implied term in law, that, as Lord Leggett described it in that case, is a default rule. And I would say thirdly, although Barton was not such a case, that when you look at all of the authorities coming out of the construction context, it is probably the context in respect of which contractually quantum merit most often comes up, and the cases that we provided you in the bundle make good that suggestion. And we say that, my little friends, 4 heads of complaint go nowhere at all. We say, one, in answer to his first point, that on the pleadings, it is not right to look at my pleading in isolation. On the pleadings before the courts, this was a case in contract. On the pleadings before the courts, it was a case in contract. I pleaded no contract, but that was an issue that the court had to decide. On the case against me, in respect of which I had to resist, I was faced with a suggestion that there was a contract, and I had to try to resist that. I've already made my second point about the 2 causes of action in quantum merit. That's his second point, so I won't respond to that. And then his third point, or his last point, his fourth point, really had to do with manifest unfairness. And I say that there was no procedural unfairness visited upon NH in the way that they've complained. They made no such complaint in the Court of Appeal. And in any event, portions, I'm not going to try to characterize the percentage, portions of my claim for quantum merit were conceded and accepted and agreed from the get-go. And there has been no request or suggestion that my learned friend for the appellant or the appellant can seek to be relieved from those concessions. And then lastly, we say that the Court of Appeal's judgment is a careful and detailed analysis of all of the issues that both appeals gave rise to, and that there is nothing in that judgment that should cause the board either to identify an error or to set it aside or qualify it in any way. It is far too late for that. This case approaching its 20th anniversary in the system. My Lord, subject to what any questions my Lords might have for me, very properly and no doubt challenging for me to answer.
No, thank you very much.
Deeply obliged. Most grateful.
My Lords, just a few points.
I think Mr. Benjamin's finished slightly early. I'm sure you understand that doesn't extend the time for reply.
No.
One can hope, my Lord. I will start with Mr. Benjamin's first point about the concession in relation to the question that Lord Richards asked me. In my respectful submission, there's a significant difference, a fundamental difference, between a situation where a party actually concedes liability and in which, on the way I understood Lord Richards' example, was where it appeared to the court that there was some liability. In this case, there are areas in respect of which NH conceded liability for a particular sum. What that effectively did is it took those areas out of scope for judicial determination, in a sense. It's an accepted liability. I understood the example from Lord Richards, or the question from Lord Richards, rather, to be dealing with a situation where it might appear to the court that there was some liability. What was a court to do? And my answer to that was, and remains, almendi, which is essentially, it is not for the court to resolve, to find for a claimant on a basis that a claimant has not pleaded or formulated in its case at trial. Now, Mr. Benjamin makes another point. He says, and he takes you through a lot of the transcript material, and he says that there was no cross-examination on FIDIC. Well, with respect, there's no surprise, because FIDIC was not the agenda for the trial. Mr. Benjamin's extensive reference to the transcript and the evidence, in our respectful submission, demonstrates really the unfairness. Because what that exercise shows is that it is now at an appellate stage that these issues as to whether there had been compliance or whether the contractor had satisfied the provisions in relation to FIDIC is now being examined. That is a matter quintessentially for the trial court. That is a forum for those issues to be raised. It cannot be right, it is our respectful submission, for those issues to be interrogated in a setting when NH had no notice that they ought to be interrogated at that time. Now, insofar as the board is minded to look at those issues, and it's our respectful submission that it ought not to engage in them for the purposes of this, but there are certain things that will reveal themselves. If one looks at page 821 of the record, that is a witness statement of Mr. Simon Jardine. And at paragraph 60 of that witness statement, what he's telling the court there is that as early as February, 7th of February 2006, there were difficulties with the ground conditions. He says there's a report from Geotech. At this meeting, it was disclosed that the gravity test report had been submitted on 1st of February 2006 to TA. The results of that test showed a hard ridge shaped like turtleback beneath the soil, and the parties were attempting to find a way forward. We were never provided with the report. Now, what is the significance of that? Well, there was some discussion in the course of when I was addressing the board about an April date and claims being made at that time and the letter. But what this shows is when one looks back at clause 412 of FIDIC, the requirement of the clause is that you serve your notice to the engineer as soon as reasonably practicable. And it takes you to subclause 20 as well, which has a 28-day time horizon. Now, the reason I point that out is this is precisely the type of matter that would be interrogated at trial if this was on the agenda for trial. There would be discussion as to whether the notice was served during time. But because NH was not being asked, and there was no allegation against it in respect of breach of contract, these issues were not engaged. And I say that by way of example. You were also taken to a letter of the 9th of May. I think it's at page 1110 of the record.
1,110. Thank you.
And that letter was a letter which was issued by Turner Alpha to NH. And that did in fact deal with an extension of time, and it did in fact deal with an award for $3.9 million. But this was a matter which was explored in the court below, in the Court of Appeal rather. There were submissions on it by the parties. And I will just give you the reference for your note. It's from 3120 all the way to 3122. I'll make the point about the letter. And what was being suggested here, there rather, and we continue to suggest here, is that this was an extension. First of all, this is correspondence passing between NH, who's the main contractor, and the engineer for the job, Turner Alpha. This is not communication passing between Gordon Winter and Turner Alpha, because Gordon Winter has a separate relationship with NH. So insofar as one has to consider the application of FIDIC, really you have to be looking at correspondence passing between Gordon Winter and NH to see if there's any satisfaction in relation to the terms. But what we do know is that Gordon Winter, and it's a agreed fact, left the site on the 2nd of June, 2006. This letter is dealing with what we say is a prospective extension of time given by the engineer. You will see at item 1, it says NH shall receive an extension of time for the completion of works of 10 calendar weeks extending the completion date from 27th of August 2007 to 5th of November 2007. And then it goes on at item 2, and it shall receive an additional payment of $3,900,000 in accordance with the attached schedule to complete the piling. So it is our submission that when you come to look at this, this is an extension of time for prospective delay. It does not pick up and is not intended to pick up delay damages in respect of Gordon Winter's time period, because he had already left the site. Now, it is true that the letter does reference Gordon Winter, because it says the amount allows for additional payments that NH must make to their specialist piling contractor, Gordon Winter. So what we submit, Turner is simply saying, is insofar as you owe Gordon Winter, you can use this money to discharge some liability. But, importantly, Turner is not in a contractual relationship with Gordon Winter, and it is not for Turner to evaluate whether Gordon Winter has complied with its contractual relationship obligations or requirements with NH in order to entitle itself to payment. So in my respectful submission, the letter does not do that which my friend says it does. It is not intended to be, nor is it an award in respect of any delay damages occasioned for the period that Gordon Winter was on site. This is Turner, the engineer, making an award for NH, the main contractor. So that's the point I wanted to make about that. There was some discussion about the Scott schedule. My recollection is similar to Mr. Benjamin in parts, but different in other parts. There was no formal order made.
There was
no formal order was made
yes,
for the production of a Scott schedule. In the course of the appeal, Justice Rajkumar requested it from the parties. And in compliance with that request, the parties provided it. That is to be found at page 3217. I believe Mr. Benjamin took you to it. And my submission is that when this Scott schedule was provided, this Scott schedule was provided by NH in the context of dealing with the claims on a restitutionary basis. Now, where will you see that? On the right-hand side of that Scott schedule, the second to last column, we can take the first page as an example. There is reference to certain submissions made by the respondents. And one of those submissions, very fine print, but refers to the pleadings issue. And it refers back to the submissions. So what it says, I myself am having trouble reading it. What it says is the pleadings issue, see the respondent submissions, paragraph 28 to 35. And what that pleading issue is, if we correlate it with the record, that pleading issue speaks, and it can be found at page 2791, all the way through to 2796 of the record. What is expanded there is a pleading issue in the context of unjust enrichment. So my submission is that the Scott schedule, it would be wrong to say that the Scott schedule somehow amounted to NH, because I believe that, I understand this to be a suggestion being made, that somehow NH engaged with a claim on a different footing than that which was advanced before the trial court, i.e. some kind of contractual or quasi-contractual entitlement on the part of Gordon Winter. The Scott schedule was, if it was anything, it was not that. So it is out of context. Because what is being suggested in my respectful submission in a context which is not intended. What NH did say, and you will see this at paragraph 28 of its written submissions in the Court of Appeal on page 2791, is that the appellant's, I will read it out, it's one sentence, the appellant's case is limited by and must be analyzed in light of the pleadings. So at no point in time was NH to be taken to have conceded, rolled over, or remained silent on any case being advanced or the court deciding a case on a basis different than restitutionary quantum merit. The short point was hold Gordon Winter to its pleaded case. The next point to which I'll briefly turn is the question of standby. A question was asked about really what is the nature of standby. I understood the respondent to be saying, well, it's not really delay. We don't accept that, and neither did the Court of Appeal. So if one has regard to the judgment of the Court of Appeal, there are a few paragraphs that bear this out in our respectful submission. If we can turn to 318 of the record. Paragraph 211, which is just above the middle of the page. The first sentence tells us, second sentence tells us the answer. It claims that this is in relation to manufacturing standby costs. It claims that this relates to time during which plant, equipment, and labor stood idle at the pile manufacturing plant as a consequence of delays attributable to the respondent. That's manufacturing standby cost. Then if we turn a few pages over to 324, at paragraph 233, the claim is for standby static test in the sum of 1.2 million, is rejected by the respondent for various reasons, including it is a delay damages claim. Then Justice Rajkumar goes on to say, however, there is no reason why a delay damages claim could not succeed under this contract if the fault were attributable to the respondent. So the Court of Appeal is dealing with it as a conventional delay damages claim. Again, at page 328, paragraph 327, this is standby augering equipment. If we pick it up from the third sentence, which is the second line, this is Justice of Appeal Rajkumar again. He says a claim comprises a claim for 9.7 hours per day for the number of days that the auger was on standby at unit rates. Again, delay. So these are, we respectfully submit, conventional delay claims. And the Court of Appeal understood the claims as such. Now, there was some discussion as well about, or rather, there was a submission about the course that NH took in the Court of Appeal. Didn't run these election arguments and so on. Well, there are a few reasons for that. First of all, NH's position was hold Gordon Winter to its pleadings. That's the first position. The second position is look at the grounds of appeal. The grounds of appeal, and if we pick it up at page 2660, we will see what was engaged on the appeal. First of all,
2660.
yes, starts there.
We're getting into borrowed time, Mr.
Well, yes, I'm going to conclude in a minute or two. The point I'm making about these grounds of appeal is, first of all, Gordon Winter was saying
to the Court of Appeal, there is no contract. We are appealing against the finding of the first instance judge that there was a contract. There is no claim at all that the first instance judge was wrong in failing to find on contractual quantum merit. And the reason for that is obvious, because as we now know, contractual quantum merit was not argued at first instance. So it was not an agenda for the trial, nor was it an agenda for the appeal. Thirdly, even if Gordon Winter raised it on appeal, they certainly weren't given leave to amend their grounds of appeal. NH never conceded, and you will find this nowhere in the record, that such a ground or basis could be run in the Court of Appeal. And apart from all of that, we submit that if it was being run for the first time in the Court of Appeal, and it would be required to have some kind of factual footing because you are running a different case, the Court of Appeal should properly have declined to entertain it. And if it didn't entertain it, then we are entitled to come to the board and complain about it. And finally, we say this, that it really is a non-point for this reason. The Court of Appeal's decision is not a contractual quantum merit decision. It is a decision, as with respect we have shown today, is a decision based in contract with an express term for payment.
With a what?
With an express provision for evaluation and for payment. So it is an academic discussion we submit, because it would amount to an argument that we conceded or allowed a case to be run on a point not found by the Court of Appeal, and therefore is not an issue to engage the board. Unless I can be of any further assistance, those, my lords, are my submissions.
Thank you. Well, the board is most...
Can I just give you two references? This reference is for context. I don't want to argue anything. One to the judgment and one to the grounds of appeal. Just for your note, my lord.
Well, just
On the
tell us what
3.9
basis.
million point, paragraphs 146 to 150, pages 294 to 295, you will see what the Court of Appeal had to say about that.
Sorry, does it page 29?
294 to 295,
Yes.
paragraphs 146 to 150.
Yeah.
And on my grounds of appeal, I'd invite your attention to ground number 4.
Yes, but I've already noted that.
My lord, I thought you would. I apologize.
Thank you. I was just about to say that we are nonetheless still most grateful to counsel on both sides and to those who have no doubt assisted them behind the scenes for the thorough and helpful presentation of their respective cases. The board will take time to consider its judgment.
My lord, would you just permit me to apologize again for Mr. McQuilkin not being here? It really had to do with the timing of the visa, and we're very, very sorry.
The board is also aware of these visa problems, and as you probably know, when it's reported to us, is doing its quite swift best to deal with them.
I'm deeply obliged, my lord.
But that doesn't make it a satisfactory situation.